Diana Levine, thanks for joining us today. One would never really expect to see amicable agreements in any kind of divorce. I mean, but by their very nature, they involve conflict. But we're some way off, sort of, even for the tiny minority that this affects. We're some way off reaching an ideal solution. We're going to see more tragedy, as you say. We're going to see women who have a divorce in one sense, but are unable to carry on their lives in a religious context in the way that they would want to. They can't remarry, their children would have difficulties. That's going to keep happening, isn't it?
Not if people will inform themselves through this e-book, Getting Your Get, at the website. And when I say people, I mean individuals as well as their solicitors. It's actually been referred to as the Aguna Prevention Kit. I haven't had an opportunity to mention yet what an Aguna is, but we have actually been talking around it. It's a woman who is in the situation where she has no get, but either has her civil civil divorce. Now, in that situation, she's unable to remarry. She's called an aguna, where her husband is refusing to grant it. Now, this e-book provides the information, the tools, the advice that people need, as I say, whether it's for their solicitors or the individuals, in order to avoid this from happening.
Just to put you on the spot now, if someone asked you in 30 seconds what your best advice would be to a couple about to have a divorce, there doesn't seem to be any apparent animosity, but who knows, what briefly would you be telling them as a lawyer and as someone of the Jewish faith? What would you be saying to them?
The ideal situation is that the couple should have their get before the civil divorce takes place. This can be achieved. If that is not something which can be done, then the fallback position is to incorporate an agreement for the get to be granted and accepted within a general form of agreement, which would be endorsed by the court as part of the court order. It's called a consent order. What I would advise very strongly is that one way or another the get should be dealt with, because frankly there's always going to be something in the negotiations that take place. They've got to deal with the finances, they've got to deal with the children very often. So too the get in an ideal world would happen beforehand and so wouldn't be caught up. But if it's necessary, then the get should be involved within as part and parcel of negotiations. There will always be something that one party wants and is prepared to give in exchange for the get. Just one final point, the advice I would give is please don't leave it until after the civil divorce the divorce decree has been granted, because that way all the problems we've been discussing may arise. So it's prevention.
And I think this is why you emphasise how important it is to get your get from the right place, from an orthodox place, so it covers absolutely every contingency.
It doesn't just cover every contingency, it also is universally accepted throughout the Jewish world. The difficulty with the other types of get within the other groupings of Judaism is that they're not universally accepted. But if anybody wants to have a more universally accepted Jewish divorce, then it can only be from the Orthodox.
Families, by their very nature, can change their attitudes to their religion. They may, as you say, regard themselves as Jewish but not be particularly observant, but then suddenly something might change. So it's always worth doing it in the way you suggest.
It's a defence against future disaster, basically, is the way I think it's appropriate to describe it. Because, as you say, people do change, and for a woman who doesn't have a get, she can't speak for her future children. If the husband is refusing to grant the get, sometimes the husband refuses to grant it, occasionally the wife will refuse to accept the get. But I regard it as an abuse, an absolutely total and fundamental abuse of the Jewish law when a husband refuses to grant the get. And people say, well, you know, it's the mother who's affected because she should be careful, but in fact it's the former husband, former in civil terms, current in Jewish terms husband, who is abusing the law and whose actions, or rather failure to act, is having these adverse consequences for the future children. So it's a shared responsibility.
Just how successfully has the latest Act, the 2002-2003 Act, changed matters for the better? Can you describe that and give your assessment of how things have got at least a little clearer?
The situation has improved significantly for several reasons. Let me just briefly explain what this Act does. The baseline is that husband and wife have to cooperate to have the get. If one of them is not cooperating, the other one who wants the get can apply to the court for the, after decree nisi, but before decree absolute, for the civil divorce not to be made absolute until such time as the get has been obtained. We've been unable to track down information from the courts because of the way the courts operate, I'll put it that way. However, we have had feedback. There's a number of ways in which it can help. First of all, if an application is taken all the way there, then in the majority of cases, and let's assume it's the husband, if the husband wants the civil divorce, he will proceed to agree to the get. Basically, as I say, the civil law is suspended, if you like, until such time as the get is obtained. Another technique that's used, bearing in mind the civil law, is for the solicitors for, again, let's assume it's the wife who wants the get, will simply only have to use it as a threat, because that husband will then have to pay for the cost of the application, and that he doesn't want, so it's far easier for him to do so. So, as I say, feedback that has been received demonstrates that it is having a very helpful impact on this issue.